Man, oh man, the plaintiffs in these AI cases just get more and more desperate as time goes on, and we're going to see that over here in In Re Google, where they're trying to kind of pull a fast one with class certification by doing exactly what the judge had warned them earlier not to. I mean, this is exactly what had happened with this a few months ago. I didn't cover it, but they were trying to slip in this crazy class definition, and the judge smacked them down for it. So we've got 3 documents to look at. The first one is just kind of background, and the second one, well, Google's asking for sanctions. Yeah, we'll see what that's all about. But first of all, let's talk about their attempt to make this class action. To justify class treatment, plaintiffs must prove that there are critical questions or issues that can be resolved on a class-wide basis that predominate over individual ones. That's the idea of a class action. You've got a lot of people who are in the same boat. It'd be ridiculous to have the same trial over and over and over again, just do them all at once. The centerpiece of plaintiff's motion, a purported methodology to ascertain which works were used to train Google's AI models, is an abysmal failure, rife with errors, and wholly unreliable. But a class would not be appropriate here, even if there were some infallible list of every work Google used for training. Who owns the work and the rights allegedly infringed? How? Under what law? Was the work registered? Validly? When? Did Google have a license to use the work? From whom? To do what? Does fair use permit use of that work? Is the claim time barred? These questions are all individual, as are the work-specific questions needed to assess the existence and amount of damages, if any. Plaintiffs make no attempt to explain how these questions, or the countless others that would arise across a class, could be answered with common evidence. And if you remember, we've been talking about exactly this sort of issue with the settlement over in Bart's v. Anthropic, and just the overall deluge of authors who are complaining about that settlement. Some because of the settlement itself, the publishers are just settling for pennies on the dollar, but a lot of them are because a lot of these authors are in very unique situations that don't generalize well to a class. And that's been enough to make me pretty solidly convinced about what I've kind of been convinced about up until then, which is that there should be no such thing as a class action copyright infringement case, because everyone's copyright is going to be different. But even as problematic as that is, as they mention over in the next page, the class certified in Bart's was limited to claims of infringement based solely on torrenting. Because remember, the rest of the case was thrown out. All the AI stuff about training, completely fair use. The exact questions they're talking about here, gone. And it's just a piracy case, just about torrenting, and they still have those amazing problems. And over in Bart's, the court refused to certify a proposed class of works used for training. No court has ever certified a class anything like the copyright classes plaintiffs here have proposed. Plaintiffs' new class definitions dramatically differ from the one offered in the complaint, were concealed from Google up until plaintiffs filed their motion, and reintroduce a fail-safe element that led this court to strike plaintiffs' prior definition. And they've been through this before, and as they're about to point out, the judge really got on them for it. The court previously admonished plaintiffs' counsel for failing to disclose their intention to significantly alter their proposed class definition. Plaintiffs ignored the court's explicit warning. But it's even worse than that, because they're trying to slip this new one in at the 11th hour, like we're seeing in so many other cases, that kind of dirty pool where you just kind of slip it in and make it so that the defendant can't really defend themselves from it. Plaintiffs had every opportunity to disclose their new class definitions to Google and the court, but they never did. Plaintiffs' motion offers no explanation for their new definitions or any excuse for their failure to disclose them earlier, even though they knew and disclosed their intention to the proposed experts months ago. This isn't actually a new thing. They've been planning this for months. They told it to their experts. The court should deny certification on this basis alone. And the problem is still that there aren't really any common issues that predominate. They're all individualized questions and they go over them. And also, Google's defenses are individualized. Courts, including the Ninth Circuit, have refused to certify copyright class actions based on defenses and the individualized inquiries they would require. In this case, individual defenses such as license, fair use, and time bars all require individualized proof. Imagine if they had to cross-examine each and every one of the class members. That's not going to work very well now, is it? That would mean they would have to be separate cases. And then there's the fair use issue. Plaintiffs contend that Google's fair use defense will be resolved through common proof. Perhaps if the court joins two others, and of course he's talking about Bartz and Cadre, two others in this district in holding that training on copyrighted works is so manifestly transformative as to render it fair use as a matter of law, which means Google would win hands down and this case would be over. But beyond recognition of Google's obvious transformative purpose, a fair use analysis requires a case-by-case and work-by-work analysis. It is difficult to see, and plaintiffs certainly do not show, how these work-specific factors could ever be established with common proof. The nature of each work and the amount of any work used will require individualized evidence. Expert hand-waving about presumptive harm to theoretical markets for works generally is no substitute for the testimony of the named plaintiffs who all candidly admitted that Google's training actually had no effect on the market for their particular works. And how many times have we seen that? They actually admit, yeah, it hasn't done us any harm. And then there's the weirdness of even figuring out who the class members are. Unsurprisingly, plaintiffs have not shown they can identify all members of the classes they propose, such as the owners of each book that Google supposedly illicitly acquired for training or of each image Google used in the training process. Plaintiffs proffer a data analyst, Mary McCarran, but her approach is mere guesswork and yields absurd results such as, check this out, matching the agenda for a 2010 meeting of the Edmonds, Washington City Council with a French language book published in 1979. I can't write satire like that. And McCarran actually said, I wouldn't consider that a mistake. It's just how the text matching works. Oh, is it now? You don't say! Well, maybe that renders the whole thing invalid. So their conclusion, plaintiffs cannot mask the fatal flaws in their individual claims by pretending to act on behalf of an imaginary class. Certification should be denied. But that's not all they're asking for. Because remember, the judge already admonished them about this once, so they are asking for sanctions. So in a separate filing, they say plaintiffs have once again flouted the court's order and governing procedural rules by engaging in class litigation by ambush. Plaintiffs abandoned the class they actually pleaded, tacitly admitting that it cannot be certified, but they cannot avoid their problems by conjuring up new classes at the last minute. Plaintiffs' freshly minted class definitions were never disclosed during discovery and were in fact affirmatively concealed. Even now, plaintiffs refuse to reveal when they devised these definitions, but depositions of their proposed experts revealed that plaintiffs have intended to use them for months. This court has already called out plaintiffs for such gamesmanship earlier in the case. The court found that plaintiffs violated a prior order to disclose new allegations during the consolidation process. They did so by introducing an impermissible fail-safe class definition in their consolidated complaint without leave and without notice to Google. The court admonished plaintiffs. Plaintiffs disregarded this clear direction. Plaintiffs' midnight switch in class definitions has prejudiced Google by forcing Google to pursue this case and provide massive volumes of discovery for 2 years based on the proposed definition plaintiffs pleaded, rather than enable Google to focus on the definitions plaintiffs kept hidden. The court should sanction plaintiffs by striking their class allegations from the operative complaint. Just make this not be a class action, Judge. Well, it's an AI case, so we already know the plaintiffs have no class. Google moved to strike the new class definitions as fail-safe. The court agreed, finding that it could not determine who is a member of the class without deciding the merits of each potential class member's claim. You gotta individually litigate them basically to figure out who they even are. It's not how class actions are supposed to work. That's when they would each need to be individual lawsuits. Well, not necessarily individual lawsuits, they could be co-plaintiffs, but they would have to be named plaintiffs in the action, not just a class. Plaintiffs attempt to certify 2 new classes and 3 subclasses that were never pleaded or disclosed violates this court's explicit directives. Here, the appropriate sanction is for the court to strike all class allegations from plaintiff's complaint. The court could not have been clearer in warning plaintiffs. The court expressly faulted plaintiffs for failing to be transparent about changes to their class definition, yet plaintiffs ignored the court's warning, violating the court's pretrial orders in at least 3 ways. In short, plaintiffs had multiple opportunities to do the right thing, but chose not to every time. Because plaintiffs have repeated the very behavior this court warned them against, Rule 16F sanctions are appropriate. By falsely representing they would continue to pursue a broad class of all U.S. copyright owners of works used in training data, plaintiffs inflicted massive discovery burdens on Google instead of focusing discovery on the actual classes they intended to pursue. Google had no notice whatsoever of these class definitions until plaintiffs filed their motion and must now rebut plaintiffs' new allegations in the space of just a few weeks. And the court has already highlighted the unfair prejudice to Google that plaintiffs' shifting sands approach is causing. These are major, substantive changes that Google knew nothing about until it received plaintiffs' certification motion more than 2 years into the case. Google could have probed these new issues in discovery and fashioned its opposition strategy. Plaintiffs' non-disclosure deprived Google of any meaningful opportunity to do so. For these reasons, Google respectfully requests that the court sanction plaintiffs by striking their class allegations with prejudice. Now, the way motions work is you make a motion, the other side gets to respond, then the first side gets to reply to the response. The plaintiffs responded, but unfortunately, we don't get to see that. They haven't made that document available to us, but they did make the reply available, so we can tell based on their reply what it was that plaintiffs said. And, wow, yeah. Plaintiffs deliberately concealed their plans for months and even now express no remorse or legitimate justification. Instead, they offer a stream of baseless excuses from the claim, contradicted by their own experts, that their new class definitions were in flux until the moment they filed their twice-delayed motion, to the meaningless proclamation that they have never been required by any court to set out class definitions before moving to certify, to the untenable assertion that their non-disclosure is harmless because Google would have opposed class certification anyway. Plaintiffs' misconduct merits sanctions in the form of striking their class allegations. Plaintiffs concede that they failed to disclose their proposed class definitions before filing their motion, and they do not deny that their failure violated multiple court orders and their basic discovery obligations. Plaintiffs chose not to meet and confer as ordered, supposedly because meet and confers are highly uncommon before class certification, and any conferral would have been futile. But whether meet and confers are highly uncommon in other courts, this court expressly required them, admonished plaintiffs for failing to confer regarding class certification previously, and instructed plaintiffs to scrupulously follow the court's orders. The judge told you to. Doesn't matter what other courts are doing. Plaintiffs claim Google could have cured any prejudice by taking discovery in the 5 weeks between plaintiffs' motion to certify and Google's opposition. That is unserious. Expert definitions after plaintiffs revealed new classes are no substitute for the extensive fact discovery taken before plaintiffs disclosed their secret plans. It would have been entirely unworkable for Google to restart fact discovery on the new classes in that brief period, while it was preparing its opposition and Daubert motions, deposing experts, and preparing its own expert reports. The court's directive that plaintiffs communicate frequently and transparently about their class plans was intended to avoid this obvious prejudice to Google. Plaintiffs' repeated wrongdoing in the face of this court's explicit warnings warrant striking the class allegations. The more modest sanctions plaintiffs propose are no sanction at all. Oh no, you don't have to do anything to us. We didn't do nothing. They would reward plaintiffs with more time to waste on distractions and overbroad discovery. And they would compound prejudice to Google, which has already been unduly prejudiced by plaintiffs' delay and the discovery in this massive and complex case. So basically, their response made it even worse. Plaintiffs' all too familiar misconduct comes after a direct admonishment at a critical stage and is patently unfair to Google. Google respectfully requests that the court sanction plaintiffs by striking their class allegations with prejudice. And since Judge Lee had already told them not to do this more than once, I don't imagine she's going to be happy. But we'll have to see what she does. I just hit F5 on the docket page and so far nothing from the judge, but man, you are seeing how desperate plaintiffs are getting. And that's going to be a recurring theme in a few other videos coming up. Plaintiffs acting out of desperation, horrendous misconduct, for this one even sanctions. And I think there's really only one logical conclusion. These cases are falling apart, and they know it. The AI cases are becoming spectacular slow-motion train wrecks. I think it's going to be fantastic to watch, and if you want to watch it with me, then please, comments for the Comic God, shares for the Share Throne, please hit like, subscribe, and the bell, and of course, donate.bogosity.tv keeps me doing this, whether with one-time donations or regular support to get these videos early and ad-free, and other benefits as well, so please check those out. Until next time, stay strong and be free.